So good morning, everyone, distinguished guests, esteemed panelists, respected moderator, sir, and all the participants in this session. I am Ayush Paudel, currently working at SORTI as a research officer. So it's my great honor and privilege to welcome you all to the day 2 of the 15th South Asia Economic Summit, Unleashing an Equitable Green Transformation in South Asia. So I believe without further delay, I would like to welcome our esteemed moderators and panelists to the stage for our parallel session of Day 2, Sustainability-Based Trade Measures, an Emerging Challenge for Global Trade. Please join me in giving a warm welcome to our moderator of the session, Professor Dr. Murali Kallumal, Professor, Center for WTO Studies, India. We have our first panelist, Ms. Visakha Srivastav, Senior Research Fellow, Center for WTO Studies, India. Dr. Salim Rehan, Executive Director, South Asian Network on Economic Modeling, SANEM, and Professor, Department of Economics, University of Dhaka, Bangladesh. Dr. Salamat Ali, Trade Economist, Commonwealth Secretariat, UK. Dr. Aparna Sawhney, Professor, Jawaharlal Nehru University, JNU, India. And Dr. Joel Tratzman, Professor of International Law and Henry J. Baker Professorship of Commercial Law. He will be joining us virtually. He has already joined the session. So now I hand over the session to our moderator, sir, and you can take over from here, sir. Yeah.
So good morning to the audience here, the people on the dais and the people in the audience. I would like to thank the SWATI and particularly Ratnakar for inviting me here. So basically we are starting off with this session, which is very specifically titled Sustainability-Based Trade Measures, Emerging Challenges for Global Economy. I think when we look at sustainability trade measures, I think these are measures which actually impact manufacturing sector, trade, finance, and technology. So it's a combination of these measures which actually have triple dimensions of planetary crisis when you look at it in terms of planetary crisis, because it's something which has come up in the recent past, although it has a negotiating history running up to 2 decades and more at the multilateral level. But recently it has come to the forefront because some of the bilateral measures or unilateral measures taken by some of the members have actually highlighted the concerns around sustainability trade measures. So to discuss that, we have a very rich panel here. And I would, for housekeeping, I would like to announce the priority of the order of speaking, largely based on how evidences come up in terms of problems and issues from academic circles and how policymakers would try to deal with these issues in a very balanced and appropriate manner. So let me begin with the academicians, Joel Turkman and Aparna. So we will first call upon Joel if he's here. And then we will move to the policymakers, to begin with the youngest in the crowd, Vishakha, then Samat Ali, you, and then Salim Rehan, who is the policymaker, the academician, and the all in all. So you have the toughest job, Salim, to either collect ideas and respond accordingly. So let me call Joel Turkman.
Thank you very much. Can you hear me? It's a pleasure to join you. I'm sorry my voice is nearly gone, but I'm glad to be speaking with you. My work in this area has been motivated and captured in the work of the Remaking Trade Project, which has recently produced the VLAR framework for trade and sustainable development. And this issue that this panel is concerned with is a core issue The problem of what we called in our project sustainability standards, focused mostly on process and production methods regulation in importing countries, is a growing problem. And it's a problem for sustainability, and it's also a problem for trade. And the problem really is a fundamental problem of different regulatory goals in different states. And states may want to have goals for their own society and then impose the regulation that contains those goals on imports from other states. Or it may be that private companies like Walmart or Amazon set standards, and we see more of these private standards. And these result in costs being imposed on exporters. Sometimes the costs are because of diverse private standards or diverse national standards in export markets. And the way that this can be resolved is sometimes by harmonizing these kinds of standards, by entering into agreement on these types of standards. So the focus is on this, what is called in the international trade system, process or production method regulation that looks at how goods are produced in the exporting country. And they're common in areas like agriculture, fisheries, manufacturing, even labor rights. And the importing country is concerned about sustainability standards, sustainability spillovers from the exporting country. We can see this in the European Union's carbon border adjustment mechanism or in regulation. We can see it in early cases from the 1990s of which continue relating to United States regulation of the way that tuna is caught, the question of whether it's safe for dolphins or not. There's a concern about regulatory spillovers, clearly with climate change or regulatory competition. Sometimes the regulatory competition is an overblown concern. There's not so much empirical evidence that regulatory competition is a serious problem. And then we also have the proliferation of private standards, which are much tougher to deal with at the international legal level. So exporters are concerned about inefficient diversity of standards. They're concerned that they're not part of the process of setting those sustainability standards, and so there's an insufficient focus on the interests of exporters in formulating those standards, and the cost of compliance and of demonstrating compliance, keeping a chain of evidence of compliance through tracing in developing countries is especially costly, particularly for small and medium enterprises. So these are non-tariff barriers. That doesn't mean that they're bad, but they are barriers to trade. And in that sense, for developing countries, they can be barriers to development. In the World Trade Organization legal system, there's some uncertainty about these types of standards. First of all, it's by no means clear that they're covered by the main standards-focused agreement in the World Trade Organization, the Technical Barriers to Trade Agreement, because it only covers standards that are process and production methods if those are product related. And it's unclear what that means, so it may not be covered by the Technical Barriers to Trade Agreement at all. That reduces the regulation of these standards, but it also deprives these kinds of standards of a kind of protection from criticism where they are international standards. And international standards are standards that are made by organizations that are open to membership by all members of the WTO. And so that provides a certain inclusiveness of formulation. So the Technical Barriers to Trade Agreement may not apply under the original General Agreement on Tariffs and Trade, which is still part of the World Trade Organization. it definitely does apply to these standards. And there is a significant chance that these kinds of process or production method standards will be found to be discriminatory and illegal unless they're exempted under Article 20, the exceptions for protection of human, animal, or plant life or health, or conservation of natural resources. Article 20 has some uncertainty, but as in the technical barriers to trade agreement, if that were applicable, if a measure were based on a true international standard, it would be likely to be found legal under Article 20. And we have the recent experience of the panel report earlier this year in the Malaysia, in the EU's biofuels case, challenging the EU's Renewable Energy Directive 2 relating to indirect land use change. And there, the panel did apply what I think of as a strict regulatory rationality test to the EU measures, finding those measures illegal under WTO law unless they're eligible for a judicially created exception from being from causing less favorable treatment, which would require them to, quote, stem exclusively from a legitimate regulatory distinction. That's a test that the appellate body devised before it stopped working. And the EU measures, in my judgment, did not discriminate explicitly, but their regulatory rationale was sufficient, but the panel found flaws in the regulatory structure, perhaps evidencing some unfairness, but not necessarily the greatest of flaws. But this strict administrative law type scrutiny seemed to, in my judgment, others may disagree, excessively restrict the national right to regulate it and seem to be a kind of judicial overreach. So in the Remaking Trade project, which I mentioned at the outset, we recommended that the world needs to develop more of these international standards through an inclusive process that would promote both sustainability and trade by reducing diversity of national standards, hopefully forcing out some of those private standards that can be difficult to comply with, and also ensuring that there's sufficient technical assistance and financial assistance and transition periods reflecting the WTO law concept of special and differential treatment for developing countries and the environmental law concept of common but differentiated responsibilities reflecting respective capabilities. And examples of standards that are needed are standards relating to greenhouse gas measurement, deforestation, fish products, maybe labor rights, circular commerce, plastics use. We felt in this project, in the VLAR framework report, that this would need to be a multi-stakeholder process that includes private enterprise, both on the producer and consumer side, as well as NGOs and governments. There needs to be a revision of the GATT that would leave room for proportion and interoperability between different national standards. This is especially clear in the greenhouse gas area relating to the European Union's unilateral carbon border adjustment mechanism. So these kinds of standards aren't a traditional field of operation of the World Trade Organization, and it doesn't really have the expertise to produce standards, but it has convening power and it has concerns. It reflects concerns about trade. This is one of those things that is not simply a trade issue. It's a trade and sustainability issue, and we need to break through silos and cross over silos and bridge them between different kinds of international organizations in order to resolve these problems. So thank you for your attention.
Aparna, you can take over. Or should I summarize what Joel said? Yeah, please take over. Yeah, I think both of you will summarize.
I can be heard?
Yeah.
All right. Thank you. And thank you, Professor Joel, for setting the stage. So much of what I will say is to complement and actually also go back to some of the things which were mentioned. I will format my comments based on two specific regulations. One, the EU CBAM that we have been hearing about yesterday and today, and of course just now, which came under the European Green Deal, which of course gets into details and multiple programs that the EU has for reaching net zero by 2050 and Fit for 55, where they would cut back on emissions by 55% based on 1990 baseline. If one looks at the intent of the EU CBAM, it is to plug carbon leakage from the decarbonization of EU industries, and it would be implemented by imposing an equivalent, and the stress is on equivalent price of carbon emitted during the production of imports outside, or EU imports produced outside. So ideally, it would also include both direct as well as indirect emissions, scope 1, scope 2, scope 3. And it would be implemented in its full form beginning 2026, which will coincide and aligned with the EU ETS move away from free distribution of EU allowances. So up until now, and continuing next year, 2025, the EU allowances on the basis of which the EU ETS works is actually not auctioned by the regulatory authority, but grandfathered, as economists typically call it, based on their initial scale of production and use of energy. So this is in anticipation of the price that would be existing at that time. So this EU CBAM payment would be accordingly adjusted. So the importers would need to buy the CBAM certificates at the average price of EU allowances. To begin with, it covers the aluminum, cement, fertilizer, iron and steel, electricity and hydrogen sector, and over time it will be expanded. The importers would declare both the direct and the indirect emissions, and then the deduction of price in case some carbon price has been already paid in the original country, it would be deducted, and the rest would have to be paid up by the importers. And from 2025, right now we are still in the reporting phase, 2025, the EU methodology of computing the carbon embedded in the imported goods would be used. It is interesting to see that this is not something that has come up very suddenly. The EU ETS was put into its pilot phase in 2005 until 2008. 2008 through 2012, which was the time period of the Kyoto commitment period, was when it was the phase 2 of the EU ETS. So the carbon market had actually crashed. The prices were like zero. And the regulators were constantly changing the rules of the carbon market in the EU. And then the Kyoto extension period, which was 2013 through 2020, was phase 3. And then phase 4, which is 2020 through 2030, we notice it's also the period of the Paris Agreement commitment time until 2030, and of course beyond that. So this is kind of a well prepared strategy, and gives a lot of legroom and time for the systems to be working and up in full functional form. The second that I will be touching on is the policy of the EU deforestation regulation, which again has the history with 2019, the EC communication, and then the biodiversity strategy, and so on and so forth, where consumption of products which are grown or affect deforestation or land degradation would be essentially curtailed, because they want to ensure that the consumption is responsible consumption. So which means if this is happening in the domestic economy in the EU, at the border, they would only bring in imports which are also responsibly produced, which means it would affect commodities like cattle, wood, cocoa, soy, palm oil, coffee, rubber, derived products like leather, chocolate, tires, and furniture. Of course, here the implementation period gives time until 30th December 2025 for large enterprises and 30th June 2026 for small and medium enterprises. I only mention this because it is sometimes important to remember, while on paper it seems there is this time given to trading partners and also enterprises, but the time that the EU has taken goes into decades. All right, so coming back to the EU CBAM, by first principles, all economic students know that the carbon price in a carbon market, if one were to consider the way carbon markets are to be functioning, would be reflecting the underlying marginal abatement cost of carbon mitigation. And it will also reflect the rules governing the permit market. It would be based on the supply of allowances, the sectors which are covered, the banking of permits, and so on and so forth. So the prices in the compliance markets across the world as of today are very different. So there are about 20-some countries which have compliance market, not full national markets, some subnational, also not covering all sectors. But the difference in the prices and the coverage of the sectors are very different. The difference in prices in what is observed in the EU ETS versus, let's say, the new national carbon market in China or in Korea, sometimes the difference can be as much as 10 times. So it could be as low as $12 per carbon equivalent, 1 ton of carbon equivalent in a country like China or Korea. Whereas in the EU, the current average price is about $70 per ton of carbon. So the price determined through a global market, which is something that we keep thinking about and which we are committed to and we have agreed to under the multilateral environmental agreements in the Paris Agreement, is very different from when a country extends its own price in a carbon market to say, I'm actually going to, I'm out of time?
5 minutes more.
Okay, 5 minutes more, all right. So determining with a global market is very different from imposing a domestic price. The EU CBAM in that sense actually is shifting the high marginal abatement cost of its own producers onto other countries that it's trading with. So essentially, it also defies the entire efficiency argument of carbon markets, the entire flexibility of carbon markets of trading carbon freely so that the marginal abatement cost is equalized, which is the reason we talk about markets and market-based instruments. That in itself is defeated here. So the EU also claims that the CBAM would be made WTO compatible. So yes, in the sense that it is extending the same treatment of its domestic producers vis-a-vis producers from outside the EU, it is in line with national treatment. However, there is a question whether there is a violation of the most favored nation article, because if you're going to be adjusting the absolute price of carbon, then based on the percentage tax that you're putting in, the tariff rate would be different for different countries, because they might have given different carbon prices. So you might be having a 50% tariff on, let's say, an iron and steel ingots, but you have a 25% for another country, and maybe 75 for another. So wait a minute, how is it that you have completely different? So the issue about most favored nation would be that you treat all your trading partners equally. All right. Challenges, let me move to that. Well, for the South Asian countries, for Global South as well as South Asian countries, there is not a conflict in terms of the principle of pricing carbon. The fact that we have agreed in the multilateral environmental agreements, like in the Paris Agreement, that we will have carbon trading. We had in the Kyoto Protocol, where of course the developing countries didn't have the commitment to cut back on emissions, but they could voluntarily engage in trade of carbon offsets like the certified emission reductions under the CDM, the Clean Development Mechanism. The difference is in the multilateral environmental agreements, it is the principle of common but differentiated responsibilities that matter. So there is recognition of the fact that capabilities are different across countries. So this essentially, when the burden is being shifted from the high cost marginal abatement cost is being shifted to the trading partner, essentially you have violated that differentiated responsibility and capacity principle. And of course, the other challenge that we have is the institutional readiness of countries with having to price carbon. So let's say in India, we have now going to be starting off a carbon trading system. It is going to be a compliance market. So I'm not talking about the voluntary market, it's a compliance market, but essentially that setting up time is going to be important. And for the businesses to accept the fact that there is going to be polluter pay is going to take time. Imagine we are thinking about the EU even till date, after 20 years of the EU ETS being introduced, they do not have auctioning. The trade price that we see is amongst the polluters, the industries. That is the EU ETS price that we are quoting. So we still don't have that auctioning. So initially grandfathering has continued and will continue until 2025. And 2026 through 2034 is when the EU envisions that it will gradually move to complete auctioning of carbon credits. So what is the course of action? We need to have a united front in essentially saying that this EU CBAM is violating MFN, it is violating the common but differentiated treatment that developing countries should have. The fact that it is shifting the burden from the EU producers onto the trading partners, and essentially it violates the entire basis of efficiency of reaching the target mitigation on economic principles basis. At the same time, we need to get our house in order. So, up half a minute? Okay, half a minute. So in that, essentially we should have policies which are not conflicting or inconsistent. So even if we say, oh, we are doing something because we are trying to cut down our import bill, it should not be against a deforestation aspect. I think I'll stop here. When I get a chance later on, I'll come back.
Yeah. Let me just summarize what both the academicians put on the table. Yeah, let me just summarize both the academicians who put on the table. I think Joel started off with a very interesting concept of, private standards taking the center stage, and how TBT does not recognize private standards in the WTO negotiations, and how the compliance costs for businesses have actually gone up in the across developing countries. Then, he also talked about how discriminatory the private standards can be, and, and uncoordinated, you see there are close to 563 private standards world over. One of my research talks about it, and when you look at it, these are not, cannot be harmonized because they are close standards, which, most of the private standards are very closed. He also spoke about the circular economy and commerce, circular commerce, so how that can bring in serious challenges for when the private standards are accommodated into the main trade arena. Then Aparna spoke about CBAM, largely about CBAM and its issues with respect to carbon, when they pick out as carbon as a pricing factor. And the ETS, you spoke about the 3 phases and of ETS, and how I think in the second phase, where as a second point, you also spoke about the deforestation and its impact, its regulations on the products produced from the forests, which are not given certificates, which will not be taken into considerations in terms of imports into the European Union. And I think you also spoke about the carbon mitigation and its pricing differences. Price differences are close to 10 times in European market, higher than the other markets like China. Very important point was about the common but differentiated responsibilities. And you also spoke about institutional responsibilities in countries which are different, reliance on institutional, what is that you spoke about, institutional reliance, or did you? No? The capacity, yeah, capacity of countries, different institutional capacities they have. And it's true, we operate at different institutional capacities when handling these issues at the international trade level concept. So these list of products, issues put on the table, I think how policymakers would try to address them, in terms of the sustainable trade. We start with Vishaka as the first speaker, youngest and gender sensitive, being gender sensitive.
Thank you, Dr. Kallumal. And thank you to Dr. Trackman and Dr. Sani for those insightful remarks. At the outset, I would like to highlight 2 very recent and important developments in the trade policy and climate change arena. Firstly, as we are sitting here discussing sustainability-based trade measures and their implications for global trade, at the same time, we are witnessing historic advisory opinion before the International Court of Justice regarding the legal obligation on states with respect to climate change and the obligations on states for breaching their obligations under the multilateral environment agreements. And secondly, this news item from the WTO that I got this very morning regarding WTO DG's annual review of global trade developments. And it says that there is a sharp rise in trade restrictive measures by WTO members between October 2023 and October 2024 as compared to the last trade monitoring report. And if I may quote from that report, there is an increasing evidence of inward-looking and unilateral trade policy decisions creating uncertainty for the world economy. Against the backdrop of these 2 recent developments, the discussion that we are having on sustainability-based trade measures, which includes measures for the protection of environment and climate change mitigation, this discussion is both critical as well as very timely. As countries grapple with the dual imperative of fostering economic growth and addressing climate change-related challenges, they are faced with the adoption of sustainability-oriented trade measures, and this discussion has become very central to policy debates in the trade policy circle as well as for climate change scholars as well. Countries are adopting a wide range of unilateral measures in pursuance of the objective of climate change mitigation and other environmental protection objectives. While we see a whole lot of countries adopting such measures, the European Union is the forerunner amongst them. The much talked about European Green Deal is the hotly discussed topic nowadays, and the Green Deal has put in place a set of actions and policies for achieving sustainability objectives through trade. The EU's green measures are also the subject of intense debate at the WTO because of 2 reasons. Firstly, the extraterritorial application of these measures, and secondly, the potential of these measures to act as non-tariff barriers to trade. While it can be said that the intentions behind these measures are noble, for example, to address climate change and biodiversity loss, the potential impact of these measures on global trade flows in general and on developing countries and LDCs in particular is an area of growing concern. And this discussion regarding unilateral trade measures also brings into focus the broader debate surrounding the extraterritoriality of trade measures, quite a loaded phrase. And in this respect, even the WTO appellate body had made certain observations which remain very relevant in the current scenario. I would like to further build upon what Dr. Sahani talked about the EU's deforestation regulation. And one very important aspect of the regulation is that it has extraterritorial effects on the trade of other countries which are exporting to the EU. The regulation applies universally, imposing EU's own production requirements on producers and exporters from third countries, thus making the impact of the regulation felt beyond its own borders. The regulation, in a legal sense, a potential claim can be brought against the regulation, arguing that the measure is a measure with an extraterritorial effect, unilateral action, so to say. But at the same time, on the policy front, the biggest impact of the regulation is likely to be borne by the producers and exporters, which are based outside the EU, and thus problematic for developing countries and LDCs which have significant exports of the commodities which are covered under the regulation. The extraterritoriality or the unilateral aspect of trade measures has been challenged by several WTO members, and it has been a subject of considerable debate in the past. If I may bring your attention to an appellate body reasoning in a very famous dispute, or infamous dispute, the shrimp turtle dispute, where the appellate body said that trade measures which do not take into account the...
5 minutes more.
Okay. Which do not take into account the domestic realities and policies in the exporting countries may constitute, quote unquote, an unjustifiable territoriality and unnecessary barrier to trade. I would also link this to the criticism against EUDR that it is not inclusive of the smallholder farmers, particularly in the Southeast Asian region, which comprises approximately 100 million smallholder farmers. And these farmers produce significant portion of the Southeast Asian region's forest products exported to the EU. And thus, the compliance requirements such as geolocation and traceability demands may be difficult for these smallholder farmers to comply with. And moving on to the challenges for developing countries, the most important and the biggest challenge before developing countries and LDCs is securing market access in the EU and similar countries which are coming up with these sort of unilateral measures. And related to that is the compliance-related challenges. Developing countries and LDCs, and particularly the more vulnerable population within these countries like smallholder farmers, producers, and MSMEs, they face difficulty in complying with the stringent environmental standards being imposed by developed countries. And this has three aspects. First is that they don't have adequate access to finance, which is required to implement the sustainable solutions. Secondly is they lack the technical know-how. And lastly, they don't have access to the required green technology. While it's not that these countries are not taking any step towards achieving their SDGs. Some countries are very proactively implementing policies. In yesterday's remarks also it was mentioned how Nepal is doing very well with respect to electrical vehicles. India has made remarkable progress in renewable energy targets. So these countries are taking steps towards the achievement of their SDGs, but at the same time, the unilateral measures could undermine these efforts by shifting focus from development-oriented policies to mere compliance. And to conclude, I would say that while these measures have the potential to drive meaningful environmental progress, they also raise concerns about fairness, equity, and compliance-related challenges, especially for developing countries and LDCs. These measures could disproportionately affect these countries who don't have the required resources to adapt to these changes quickly. I would like to say that inclusiveness should be an important pillar of sustainability-oriented trade measures so that developing countries and LDCs are not cut out of the global value chains which they have worked so hard to enter. Secondly, there's a need for targeted support, which includes finance, technology, and capacity building. Thirdly, there's a need for enhanced multilateral discussions at the WTO regarding addressing these unilateral measures, because these measures have the potential to disrupt the consensus-based approach at the WTO and further exacerbate the existing global economic equities. And lastly, while multilateral cooperation and support is the best way to go, countries also need to develop their own domestic capacities. For example, coming up with their own indigenous compliance mechanisms to comply with regulations such as the EUDR, and also interacting with the private industry to enhance their export readiness. Thank you.
Thank you, Vishaka. Some very important points were brought to the forefront. I think one of the very important point which you brought, let me summarize Vishaka's presentation, because I think, as a policymaker, I'll go one by one. I'm changing the format, collecting the academic inputs as one, and then putting it across the policymakers. So, you said that, you brought in the intervention of International Court of Justice in these matters. You also brought the inward-looking policies about, in these countries, both, it's not just EU, but also US has come up with some of the inward-looking policies. You focus specifically on the Green Deal and its extraterritorial applications. So I would like to also point out that EU Green Deal has a geomapping, which actually also goes into the value chain. If something is produced in a particular location in India, that information has to be passed on to the EU importer. And in terms of documentation, it goes, if it leaves India and goes to, say, Vietnam, then the same has to be carried in the documentation process. When it reaches European Union, it gets all the locations. So it actually, it's a threat, national threat. Countries may perceive it as a national threat. Or, in terms of wars and, disputes, it could be used against them. So geolocation, and you actually listed out a whole amount of market access, the GVC related, and then you also domestic capacity, technical knowledge, and development compliance. So some of these issues are well in the framework of the sustainable trade issues, which is actually the topic of today's discussion. So yeah, can we move forward to the next presenter? Yeah. Feel free.
Thanks, colleagues. Very honored to be part of this learner panel of professors. So I am professional trade economist. So trade economists normally look at the things from the different perspective. So being an empirical economist, first thing I like to see is the data. What does the data say about these measures? And then we have particular frame of thinking about these kind of issues. So let me start with the data. So this says orientation of SAARC countries' exports in last year, 2023. So these countries exported around $1 trillion of exports. 3 major markets in the world, USA, EU, and China. And these are major poles of global economy. 21% exports ended up in the EU, 18% in the USA, and 4% in China. So out of these 3 big markets, 57% of South Asian countries' export ended up with other developing countries that we call South-South trade. So why this slide is important? Because economists think trade mainly from 3 angles. What countries trade, and secondly, how they trade, and where they trade. So coming to the first question, what countries are trading, especially the countries in South Asia? Mainly we are trading agricultural goods, and secondly, we are trading low value-added manufacturing. So when you are trading these 2 types of goods, agriculture sector will be exposed to EU deforestation law, as learned professors have already mentioned. And secondly, when you are exporting low value-added manufactured goods, aluminum, steel, or some products, you are subjected to CBAM. So that's important to understand what we are exporting. Secondly, how countries trade? There are only 2 ways of exporting. Either you export intermediary goods, you are part of value chains. Secondly, you export finished goods. So looking at the trade structure of the SAARC countries, most of these countries export finished goods to the EU market and the US market. So finished goods are subjective to these kind of measures, CBAM and EU deforestation law. If you are exporting steel, it will be subjected to CBAM taxes. But if you are exporting car manufactured by steel, so far it is not taxable under CBAM. So what you are exporting, that matters. Thirdly, where you are exporting, so these are three major markets. EU has CBAM, which is coming up. They started trial project. It will be implemented taxation side from the next year. The US does not have CBAM at the moment because they don't have domestic carbon price. But it is expected that with the change of presidency with Trump too, they will come up with a CBAM. China is coming up with its own CBAM. So 43% of SAARC countries' exports will be subjected to these kind of measures. But there's a big opportunity of 57% exports which go to other countries. So what these measures will do, deforestation law, CBAM, they will affect South Asia's trade through all these three channels. What we trade, how we trade, and where we trade. So as economists, we believe that comparative advantage is the basis of the whole trade. And comparative advantage is derived from the production. So when we have these kind of measures, so you have to change your production pattern. You need clean energy, you have to account for carbon. So production cost will go up. That will affect what we are producing. And second channel, it will affect where we are trading. So when you have restriction in the EU market, US market, or Chinese market, trade will deflect. It will deflect to African countries, it will deflect to other South Asian countries, it will deflect to South American countries. So there will be a kind of deflection which we will observe in the trade. So these will be kind of challenges we will be facing. So with this background framework, so let me see what we can do to mitigate these challenges. So I work for international organization. So first thing which we always suggest that we need to talk about multilateral and polylateral arrangements. Mainly, we need to strengthen WTO rules. WTO, we know is under pressure, has always been under pressure, but strengthening of the WTO is important because that is the only organization which frames trade rules. And it talks about the climate rules, and it is voice of the business in climate forums. So WTO is the only forum which will talk about trade in COP29 and COP30. It will talk about trade at COP16 and biodiversity. So we can't go out of the WTO rules. And there are other frameworks like Joe has mentioned, Bridgetown Initiative, which tries to bring trade into the climate dimension. Then other environment goods. So WTO had this agreement on climate-related goods since 2014, which was never approved, mainly because of one major issue, whether the bicycle is the environmental goods or not. So these kind of petty issues have held this agreement back. So we need to bring that debate back to the WTO and strengthen these kind of issues. Second, because most of the trade we see is regional. Around half of the trade takes place under RCEP, under CPTPP, under NAFTA, and other EU agreements. But we don't have that kind of arrangement in Asia. It's very much fragmented. We have been talking about SAARC yesterday, but that doesn't seem to be much water in the game. Maybe we need to talk about harmonized standard and more on South-South trade. So as I have shown in the first slide, 57% of the trade is in the developing countries, where I see the potential to overcome these kind of measures. And then there's a big space to learn from each other, what we call peer learning. In Commonwealth, we have the arrangement called Commonwealth Connectivity Agenda, which helps member countries to learn from each other's experiences and transfer of technologies. But much of the action has to be done at the national level. We can keep on talking about multilateral issues, regional issues, but ultimately countries have to take account of themselves. What countries have to do? The first thing which comes to my mind is countries need to get ready for carbon pricing.
Samat, 5 minutes.
Sure, I will finish in 3 minutes. So carbon pricing is coming, and it will come in other countries also, so we need to have our own arrangement, CBAM system, or water carbon adjustment prices. So it's important that if EU is going to tax your exports, why not to keep that revenue at home? So countries have to come for their own kind of arrangements. Secondly, especially for this region, we need digital tool to ensure compliance. But these kind of measures, PCAs as well as EU differentiation law, they want transparency of supply chains. We need to account for scope 1, scope 2, scope 3. We need to have tracing from farm to fork, and that can only be possible through digital tool. And the two common digital tools are AI and blockchains. And we have competitive advantage, especially in India. They got good technology background, so that can help to ensure this transparency. Third thing which countries can do is green innovation. And innovation mainly happens through two channels. One is through subsidies, another through the tax cuts. The best example for green innovation comes in my mind is Romania. Romania has exempted IT professionals from tax cuts and IT firms from the tax cut for the last 10 years, and you can see how big exporter of IT services they have become. And finally, we need to work very, very closely with the private sector, because private sector has to implement these regulations. So we need capacity building measures for SMEs as well as MSMEs we were talking about yesterday. And then financial and technical support for capacity building. So I will stop here and we can pick up some of these issues in discussion. Thank you.
Thank you so much. It was a wonderful presentation. So, you actually brought out the data onto the table. Yeah.
I did not show last slide.
Okay. You have time next. Okay. Yes. Yeah. So, you looked at the composition of trade in terms of, say, agriculture and low-value manufacturing products. That was wonderful. So we know what we are dealing with, because most often what concepts are floated globally, and these do not carry a underpinning taxonomy behind the concepts. Like green, yesterday I asked a question, green trade, what are we talking about green trade? What's the taxonomy of green trade? Composition of green goods. So I think, in that context, Pritam had thrown up the APEC list, one of the 54 products which actually could have been taken forward as a starting point. But the problem there was, largely it was export and import between the big players. So there was a problem there. And also non-tariff measures was heavily intended. Then you spoke about the solutions where we can actually look at solutions. There are multilateral solutions, there are WTO rules, the environmental goods has been already negotiated. Then you came to the regional level, harmonization, importance of harmonization. It's very important to start with the regional level. But before that, we have to take care of the national issues, which is like, finding digital tools, farm to fork, and green innovations. Some of the things which you actually stressed was actually very important. Capacity building of MSMEs and SMEs. So that's, again, one important area where we need to look and focus. Wonderful presentation. Thank you. Now we move to the last. I think he's the Don, and he can handle anything and everything. So.
Thank you, Professor Murali. I think after this 4 excellent presentation, it is extremely difficult for me to add any value to the discussion. But I thought that some of the issues, probably I'll be a little bit repetitive, but which are important for a country like Bangladesh. But before getting into that, I think there is a fundamental question to settle. When we are talking about the sustainability-related trade measures, are we talking about non-tariff measures, or we are talking about new industrial policy? Because if these are non-tariff measures, and probably will agree that these are not very clear enough yet, whether they fall into non-tariff measures category, and the kind of clarification is needed, more clarity is needed. Then probably if there are non-tariff measures are identified, then there are legitimacy issue. And then, as Professor Sahani, she mentioned at the beginning that there are issues of violation of MFN when it comes to imposition of taxes and also pricing issues of the carbon. Then the problem is whether, even if we identified as a non-tariff measures, legitimate concern of this environmental or the sustainable related trade measures, whether they are imposed on a kind of MFN basis. If they are not, then they would turn into non-tariff barriers. But I think, in my understanding so far, this whole discussion and the whole discourse on these sustainability-related trade measures have been very much, are really coming from the new industrial policy, where these developed countries, they are actually following this new industrial policy, and the South, in the South, the developing countries, and mostly the LDCs, they're still relying on the conventional industrial policy, and I can see the huge conflict between these two. The conflict is that the South will still continue to pursue their conventional industrial policy because they are still finding it difficult to adapt to the new situation, and that's what my earlier 4 panels, they have talked about it. And then how do you really resolve these issues? I think this is a very fundamental question. Now coming to Bangladesh, I think there are 4 major challenges, and I think some of these challenges which have already been identified. Limited resources, especially a country like Bangladesh, where you have problems of implementing or executing even the old conventional industrial policy. Then how these new measures, whether the industries will be able to comply with this compliance, whole issue of compliance. But again, you remember if you attended yesterday the very opening session or the first panel session, where actually I raised a question about the burden sharing of this cost. Because this compliance adds cost to the firms, and in the whole global value chain, we don't really see that kind of reflection of this cost sharing. So that's why whenever these kind of measures are actually fall into the, on the firms to comply with, and they really feel the challenges of how they can really get more integrated into the value chain. And this is more particular or more problems for the emerging sectors. Take, for example, ready-made garments industry in Bangladesh. Probably by now, they are more matured, and many leading green factories in the world are actually there in Bangladesh, the ready-made garments industry. So probably they are in a better position, though I know that they are still struggling, in a better position compared to many other emerging sectors to comply with these standards. But again, we know that countries like Bangladesh, they are in serious dire need of diversification of export basket. So how do you really then help the country to assist this, their diversification process? Another issue, I thought that country like Bangladesh also lack in capacity for data collection and reporting, because this would be extremely important when it comes to complying with these new measures. So the options for support, I think I see there are 3 areas, and my earlier panelists, they talked about it. Technical assistance is extremely important. I thought that when it comes to technical assistance, some of the collaboration should be between developing countries, LDCs, and the developed countries in terms of technology transfer, where we don't really see that much of progress. And some of the sector-specific assistance, if that can be done. The climate financing, especially with respect to this Green Climate Fund or Adaptation Fund, how the LDCs and the developing countries can make the best use of it, I think this is also extremely important. And in terms of capacity building, I think one extremely important area is that, and Professor Sahani, he talked about it, about the institutional capacity and the governance-related issues, especially with respect to monitoring, with respect to overseeing this whole progress. Bangladesh lacks serious institutional capacity. So how do you really make sure that this capacity is being developed? And also in this whole value chain, where these firms, they are procuring raw materials in the supply chain, and whether that traceability is also being ensured, I think that is also would be coming up in the future on a very important issue. So if we can't really comply with this whole things, and we know that there is a serious market access problem. Bangladesh and some other developing countries, or probably many developing countries, they will face these challenges. But here also I see there are kind of problems related to the fragmented trade regime. I think a couple of my panelists, they also already talked about it. Different countries, they set different standards. And, and we have seen in Bangladesh, take for example, in the case of shrimp export from Bangladesh, we have seen European standards are different, Japanese standards are different. Once European banned importing from Bangladesh on shrimp, and Bangladesh then diverted shrimp to Japan, where Japan was actually accepting that stream. So you see this kind of fragmented trade regime. Some developing countries can exploit this fragmentation, like taking advantage of the loopholes, but that is not really sustainable. So here we really need some kind of harmonization. I think some of the panelists, they really talked about this, harmonization, need for harmonization. And also the role of the international bodies, the role of WTO, role of the other global agencies, how to set a kind of, or bring the harmonization in the standards. When it comes to, I think, best course of action for a country like Bangladesh, I can see that the course of actions can be at different layers. One is, it can be definitely need to be sorted out through different bilateral engagement. 5 minutes? No. Oh, okay. Bilateral engagements, some multilateral approaches, and I can see that there are serious importance of this domestic policy alignment. So I thought that when it comes to bilateral level of commitment, whether there is any scope to negotiate.
2 minutes.
It's a sudden drop. I think the standard needs to be harmonized. Okay, anyway, just joking. Don't worry. I'll finish in 2 minutes. Okay, so. Okay. So I thought that whether there is any scope to negotiate tailored sustainable standards. Because we can talk about this global harmonization, and we can talk for months and years, but my understanding is that it will be very difficult to achieve in a shorter to medium term, though we can pursue for it. But in the meantime, the developing countries, whether they can actually pursue for the bilateral level or negotiate for tailored sustainability standards, and in that case, some joint initiatives for green technology infrastructure and trade, and seeking some incentives for sustainable practices. At the multilateral approach, I thought that to advocate and the collective action in terms of flexibility provisions in global agreements, I think this will be very important, where here I can see the cooperation at the South Asian level. I think one of the important points at the guiding note was that whether South Asian countries can also collaborate with each other. I see that possibility where to advocate for flexibility provisions at the global agreement and South Asian countries can work together. My final point would be on the domestic policy alignment. I think this is very important. While we talk about, we can continue talking about what is happening in the EU, US, and at the global and multilateral level, but a country like Bangladesh, they must strengthen environmental governance and enforcement, which is seriously lacking, promoting green industrial policy, and we can debate on how do you really define green industrial policies, but I think this is an area of discourse which we should really seriously start and pursue. And whether, my final point would be, whether we should also go for developing national standards for sustainability. I think this discussion, I don't see much in Bangladesh, and I'm not sure whether these are in other developing countries as well, but this is something we should also pursue. Thank you very much, Professor
Thank you, Salim. That was truly like a subject expert. You could handle all the issues and you pinned it to Bangladesh. That's a very interesting way of looking at it. You brought in some of the sustainability-related standard trade measures and its linkage to non-tariff measures. So, you also mentioned that there needs to be more clarity in terms of this measure, what is being considered a non-tariff measure. I feel, my own understanding is that it's a non-tariff measure-based standard, but it has an application of duty. So, so it is a tariff plus non-tariff measure, so it's a hybrid measure. I put it as a hybrid measure. So CBAM, looking at CBAM. You also, you brought in a very important dimension of, linking it to Aparna's point that, MFN violation should be treated as a non-tariff barrier rather than, looking at it as simply as a non-tariff measure or a duty measure. Another important point which you said was, conventional industries are struggling to match up with the measures, various measures. Here comes a new element to it, green and, all those unilateral measures from the, you took the example of green ready-made industries, which are mostly green and better placed, but they are facing serious trouble and, moving forward. You also indicated towards that. You brought in the area of capacity building, need for data collection, which is a very important element, and reporting. These are, I think, two important things which has to be kept, it has to be kept. Data collection and reporting has to be kept for 5 or 15 years, I think, with the country or the company. There is a role for technical assistance on technology, and sector-specific attempts should be made. Capacity building, you build upon the institutional differences, capacity differences, which Aparna brought in. You also looked at the value chain implications of it, and a very important aspect which you brought in was market access, ultimately, when we look at all these issues. And also the fragmented approach in terms of standards, EU standards and Japan standards, and the difference in the method and the treatment and its application. So with these, I now would like to open the floor to the general public audience. Can I have some questions here? Starting from here, Preetham. And also, next is...
Thank you very much. I'm Preetham Banerjee, Head Center for WTO Studies. And my question is for the two lawyers in the panel, but it takes from Dr. Swani's point. So we know that we have only two types of border measures that we apply. One is a discriminatory tax. Discriminatory meaning customs, which means it violates national treatment, but is MFN applied on an MFN basis. And the second is what we call an equalization levy, which is national treatment. It's my domestic tax, which I apply on my own industries, but I also apply it at the point of entry at the border. Now, I think what Professor Swani was trying to refer to is that it meets the treatment of national treatment if I assume that the intent was to match the euro or dollar figure that the European firm is paying for the same amount of mitigation vis-a-vis another firm from outside. So that's where the price difference is being adjusted. But if I then ask the question that the entire point of CBAM was not this, at least the the purpose of it was not this, it was carbon mitigation. If that is the purpose, then it violates national treatment as well. So I would like the legal opinion on this. Not only it breaches MFN, because in many cases the applied duty will breach even the bound rate of the schedules committed by European Union in many cases. Not only does it do that, well, the EU opinion will counter and say it's not a customs duty, it's an equalization levy. But if it argues it's an equalization levy, in that case, is it not tacitly saying it's basically meant for the price and the carbon was never the issue? And therefore, we can argue it's a national treatment package. Thank you. Dr. Trackman, and of course, Vishak.
Yeah, I think should we collect more questions and then respond? Yeah, sir.
Thank you, Chair. Mustafizur Rahman from Center for Policy Dialogue. My question is to Selim. Selim, you have mentioned that MFN violation should be treated as an NTM, non-trade. NTB or, okay. NTB. Okay, NTB, okay. Now, many of these standards you have rightly mentioned are also country specific, okay? So, would you like to have a strong multilateral agreement with regard to this? So this is one. And you then at the end also mentioned about developing national standards, okay, for sustainability. Then if there are multiple standards, then what should the national standards comply with? You know, that's the challenge also, the second challenge. So I'd like to have your request, your comment on that. Thank you.
Mic can go to the last, please. I think the mic can go to
My query is for the panelists. New coming US President Donald Trump is ignoring on the carbon trade related all the international instruments. How far it take impact in the world trade in the context of the climate change? And second query, WTO dispute settlement mechanism has already been collapsed from last 4 years. How it is possible to revive the distributed mechanism of WTO? Thank you.
So, yeah.
Hi. My question is primarily directed to...
Introduce yourself. Introduce yourself.
Hello. My name is Kamya. I am a young professional at the Center for WTO Studies. My question is primarily directed to the lawyers, but I think it also bodes well with the policymakers as well. And I think a phrase that was used in the previous session by some economists was fragmentation of, say, funding being development funding or climate funding. Another term that we use in law is also fragmentation of regimes, where we talk about a trade regime and an environmental regime and so on and so forth. So in this era of fragmentation, what most regimes try to do is harmonize within themselves. Like Vishakha also pointed out, the ICJ is currently speaking about this, speaking about the implications of different countries and whatnot. So my question is sort of twofold. The first question, more to understand, I mean, both of these questions are very practical and like what are the implications of the status of harmonization. The first is, what is the merit of us discussing harmonization of these international standards preemptively? That is, before all of these measures are in place, before we start seeing the repercussions of this. How would this play out? Who gets to decide how this standard has to play out? And then, given that we already see something like this Brussels effect happening, which country then starts dictating and starts the dialogue on these standards? And so that then leads to the second question, which is, when we're talking about standards, there are so many different bodies that are involved with making standards. We have national bodies that make their own standards. Then we also have the TBT committee talking about these during their meetings. So which body then, given that there is a fragmentation of regimes, when we're talking about sustainability-based trade measures, who is going to be the one setting the standards? Is it going to be an environmental body? Is it going to be the ISO? Is it going to be, say, the TBT committee taking into account the different countries' perspectives? So it's more like that.
Fragmented. Okay. So now I think we have collected a couple of questions. I think we should start with the law portion, or how should we go about it?
It should be lawful.
Lawful, yeah. Law first. Joel, are you there online?
Thank you. Can you hear me?
Yeah. We can't see you, but...
I feel that
yeah.
you can't see me. I think maybe the technical people can remedy.
Yeah, now you've come online, yeah.
Thank you. Let me begin by saying something about, in response to Dr. Banerjee's question, which of course is very well framed, and this whole panel and discussion has been extremely illuminating. You know, there is a possibility that the CBAM can be challenged as an excess tariff. But the fundamental question, even if it is challenged as an excess tariff, is whether it's discriminatory in the national treatment sense, actually, under Article 2 and under Article 3 of the GATT. And there, I do want to say that, you know, it may be that the result of the CBAM is to apply different adjustments to different countries. Dr. Sawhney explained this, that if you have different carbon prices in different countries, then the CBAM would adjust to take account of those different carbon prices, but not necessarily different other emission reduction techniques. So it's possible, and in fact, in my judgment, it may be likely that the CBAM would violate either Article 2 tariff or Article 3 national treatment, or possibly Article 1 most favored nation treatment. The fundamental question there will be whether the CBAM can comply with Article 20 exceptions. And there, you know, there's nothing in WTO jurisprudence that says that either unilateral measures or extraterritorial measures are necessarily a violation. In fact, the appellate body has said that unilateral measures are what you would expect to be defended under Article 20. And in Shrimp Turtle, it specifically avoided dealing with extraterritoriality. Here I would just observe that the general international law outside WTO law on extraterritoriality is by no means clear. And I think, just from a national autonomy perspective, there's national autonomy on both sides. If you look at the European Union, they're saying we're acting territorially about territorial harms from climate change, even though we're reaching out and seeking to govern operations in India or Bangladesh or the United States or China. So I don't think we answer questions through these legal rules so very well. And I think more work needs to be done, more governance needs to be applied. And Dr. Ali referred to the Green Goods Agreement, which failed because it couldn't reach consensus because some states sought to free ride. The focus was on bicycles, but there was free riding, and there was a failure to agree on what constitutes a green good, even though it would be wonderful for the world to have reduced tariffs on technologies that can reduce climate change. So I think that we need to work on governance. And here I come to Kami's questions. It is interesting that the European Union has provoked the rest of the world for better or for worse, and we can look at it in different ways. I think it's in some ways a benign provocation. The European Union definitely seems to be taking advantage of the Brussels effect, a first mover advantage, and seeking to start the conversation. But I think it's incumbent on us and the rest of the world to join the conversation. And I don't think it's necessarily the right path to try to do it through the WTO litigation system, through adjudication. And here, as one of the questioners pointed out, the appellate body is not operative because of the United States blockage of appointment of new appellate body members. But I think adjudication is still not the right way to deal with these major questions of global public policy. And I also feel, and this was a result of the Making Trade Project analysis, that we've come to a moment where we have fragmentation in the sense that issues are not trade issues or environmental issues or development issues, but they're combined issues. And our international organizations have limited mandates and limited expertise. And because of that, in order to address these combined issues, they really must cooperate with one another. And we also, at the national level, have to get our ministries of trade or environment or economics to work together in greater harmonization in the international setting. So that fragmentation is a result of the way we make laws in the international setting, and I think it's time to start to revise that to make laws more easily and in a way that reflects the full scope of our different countries' national values. Thank you.
Thank you, Joel. So I think now the rest of the questions are for the economists. Yeah. Oh, okay.
I think Professor Trackman has adequately addressed the questions. I would just like to add one small but very important point. In the analysis of whether the measure is in violation of the national treatment obligation, a very important aspect is whether the products are like products. And here comes the whole debate about whether a product which has high carbon embedded in it and a product which has low carbon embedded in it, whether they are like products or not. And similarly, a product which has been produced on a deforested land and a product which has not been produced on a deforested land will be like products or not. And this is a gray area, which I think going forward when these measures are actually challenged at the WTO, we'll have more clarity from the panel and eventually the appellate body jurisprudence. Secondly, Professor Trackman also mentioned about the Article 20 exception. Here, the necessity test comes into picture. So if say, for example, EU is going to argue that the measure was necessary in order to achieve for the protection of animal, human, or plant life or health, which is Article 20A, then we will have to see whether there was a less trade restrictive measure available or not. In case the complainant is able to prove that there is indeed a less trade restrictive measure, then it will be difficult for the defending country to justify that the measure was necessary for the pursuance of the objective under Article 20A, which it has resorted to. Secondly, coming to Kamya's question about harmonization of standards and whether we should be looking at national standards versus international standards. This fragmentation of standards, so to say, this is majorly an issue when it comes to TBT, because in SPS we have the three sisters, the OIE, VOA, and the IPCC, and we have a reference point for international standards, which the countries emulate and they build their national standards on. But when it comes to TBT, there is no one organization which sets international standards, and then the countries, it's up to the countries to come up with their own domestic standards, which leads to this sort of fragmentation. And so I think it's absolutely depends on the country to be more proactive in aligning its standards in the regional sense and also at the international level, so as to avoid this fragmentation in the regime. Thank you.
Thank you, Vishak. I would also like to add, it's not a question of SPS or TBT. In SPS also it is possible, fragmentation may happen. But, the fragmentation happens in terms of stringency, one. Actually, you have a higher standard than the internationally agreed measure or in the context of MRLs. And you may also have a non-codex MRL sometimes, Some countries come out with default measures. And EU recently has been coming out with many of these measures, So fragmentation is possible at that level also in the SPS case. So now I think Salim was targeted specifically by...
No, thank you, Professor Rahman. I think I would definitely tend to agree with you. There is a need for multilateral agreement there. But the path to getting to multilateral agreement, I think it's very challenging. Especially, I'm not sure about the future of WTO, the way in the Trump 2.0, and how it will take shape, and whether, to what extent and how intensively and extensively we can take these issues in the WTO and get some very meaningful outcome of it. So I think that's something for the future we should, definitely leave it. But at the same time, as I said, in that process, we should also try other means, plurilateral level, regional level, and bilateral level too, we should do that. Your second point about, I think Vishakha already responded to some extent. I think developing national standards is important. When I talked about it, it's about more of the convergence towards the international standard. But as we agree that there are, fragmentation in the international standards too. But I think if I want to be more specific, I would say that Bangladesh needs a national policy for standards for sustainability. So we don't have any kind of national policy. So I think this is something very important, so that we get the important stakeholders on board to discuss these very important issues. Thank you.
Yes, Salim, I would also like to point out there, we, in India, we have a Indian National Standard Strategy. So I think you can pick some clues from there, because you could look up that document, maybe adopt something and maybe discard some other things. Do any other panel members would like to respond to the questions? Yeah, Aparna.
Okay,
Aparna, yeah.
Okay, thank you. I think a lot of the discussion has been whether this CBAM is compliant with the WTO rules or not. So as we know, the two basic pillars of the multilateral system are MFN and the national treatment. I am not a lawyer, but the way international system is based on for trading, all goods are classified on the basis of HS system. And HS system is the basic pillar of international trading. Let me take the example of steel. So steel, which is subjected to CBAM, is classified under Chapter 73. And the WTO laws says Chapter 73 is steel. It doesn't say steel manufactured in India or steel manufactured with the green hydrogen in Namibia. Steel is steel. If you are sending steel from India to EU, it should get the same treatment as the steel coming from Namibia. So on the basis of the production processes or the energy input, so you can't change HS code of the products. HS code remains the same, so then it seems to be clear-cut violation of the MFN. Then I might be wrong, but that's my understanding. Coming to the perception of national treatment, the national treatment says that you give foreign goods the same treatment as your domestically produced goods, and then you give the same treatment to all foreign goods in similar manner. If suppose India has its own CBAM and you are taxing goods, carbon at home and sending to the EU, and your price is not equal to the EU carbon price, so you might be charged, say, $1 per ton of steel. But Pakistan doesn't have CBAM, and you are sending the goods to EU, and you get charged $4 per dollar. So there is a discrimination between goods going from India and goods from Pakistan. And then there's discrimination against the goods which are being produced in the EU. So there is a tripartite kind of discrimination. So basically, it seems that you are violating the national treatment rule also. But ultimately, WTO dispute settlement panel has to decide, which is not in place. But this is the way that the interpretation and the basic pillars of the WTO frameworks look like. Thank you.
Can I just respond to that? You know, see, when you look at the EU identification, there's a 10-digit code, there is a 6-digit code, and 6-digit is the basis at the international level, harmonized. Then 10-digit is country's national code. Then you have 12-digit, which actually takes into care of 3 seasons, autumn, summer, winter. Then you have the last 4 digits for 2 technical details. So it's 14-digit tariff system code, tariff coding. So EU can come up with that, very complicated tariff coding system for addressing the similarity-related challenges. Okay, so when you argue similarity, products are similar in terms of characteristics and in terms of product characteristics. Then you can say, okay, more than 20% carbon is this code, and less than 20% is this code, and higher than. So it can come up with various combinations and permutations and combinations. So yeah, so I think there is a concern and challenge which I want to throw up. It's been used in agriculture, and the non-ad valorem tariffs have been used largely. So yeah, just want to tell that.
This is not in response to any question, because I'm not sure I had any questions. No. This is in response to the fact that I thought I'd get 2 extra minutes.
Yeah. Okay, yeah.
Because there were a couple of things I wanted to say in terms of strategy. But before that, I'm really tempted, because both Professor Joel and Vishakha kept referring to the disputes, trade environment disputes. So without getting into like products, I think since you mentioned the shrimp turtle case, as well as Professor Joel had talked about the earlier tuna dolphin, both of the cases had dispute 1, dispute 2 kind of a thing. What was very clear from both the pre-WTO tuna dolphin case as well as the post-WTO, the shrimp turtle case. In the shrimp turtle case, the first one where it seemed the US was not justified, it was because the developing countries, which included India and Malaysia and so on and so forth, they were essentially not kind of helped. And then what India did, among other countries, they actually had domestic regulations to protect olive ridley turtles, and saying that we have also kind of put in the effort, which made sense. And it was linked to also multilateral environmental agreements. So there is this relationship between the recognition of multilateral commitments So as long as EU takes an action in terms of EU CBAM, saying that this is essentially for their commitment under Paris Agreement for the climate mitigation, it would be in that sense, quote unquote, justified. And so that is why I kind of said that, the South or South Asia in particular is not averse to carbon pricing, but it's obviously the way it has been implemented. I'll stop here in concern with those disputes. I just wanted to say I think it also adds to what Salim was talking about, that what are the strategies going forward in terms of what one can do amongst the South Asian countries at the multilateral level, a united front against discrimination and violation of common but differentiated responsibilities. Second, the regional aspect where we are looking at South Asian trade in particular and pushing for greater integration. Even things like trade facilitation, where we essentially make for smoother transport, helps in climate mitigation because you're actually directly reducing the scope 3 emissions because less trucks are idling in the border, so less emissions. But more importantly, in terms of accounting for carbon, that carbon accounting exercise is something that we really need to do at the regional level. It will also help us identify the different points in the supply chain where there is greater emissions and therefore greater scope for reducing. And at the national level, which I was kind of referring to in terms of setting our house in order and going back to data collection and reporting, simple things like actually ensuring that your energy use and the fuel mix is reported in detail, because we work with plant level data in the, let's say, for example, for India, the Annual Survey of Industries, the ASI data, or for that matter, the CMI prowess data, which is at the firm level. It is very disappointing that post 2014, we are actually seeing less reporting on the energy use by fuel.
Exactly.
So it's essentially tracking the emissions at the manufacturing plant level. For some reason, it kind of did because of the Industries Act. They made some changes and in the form and what has to be reported. Now that also, that's why I said there's issue of the consistency, and you can't have your own policy. So when India is now proposing to have, and it's going to be having a carbon market, compliance market, based on the unit of energy efficiency. And it is going to be a successor to the PAT, which was also referred to in the previous section. All the more reason that those PAT industries, which coincide with the EU's initial CBAM industries, you need to track them. So how do you, while implementing, ensure and verify these emissions? So again, these are nitty-gritties, but the basic tools that we need to really work on, and that is at the national level. That is not at regional, but only when we get our house in order at the national level, we move to the regional and then the multilateral. Yeah, I'll stop here.
Thank you, Aparna. So we have 5 minutes. If there are any pressing questions, 1 or 2 can be picked. Yeah.
Since there is some time, optimum utilization of time should also be done, resource efficiency. If you talk about Indian case, in the same industry, emission intensity of different companies are very different. Very high, which are old companies, old factories, and relatively pretty new factories are very reasonably low. What would be CBAM rate? Different rates for different companies, or same rate for all companies coming from one country? Now, if that happens, then those who are taking autonomous measures to improve their emission efficiency, they will be penalized and they would not take further measures. So, is it a good approach? Second question is that now Trump coming, he is going to act very violently if EU goes for CBAM, especially on US products coming, and China would follow suit. maybe other countries also. So what is the possibility of this CBAM getting end of light? Like we heard similar measures for several years for goods, for EU aviation tax, which they still talk about aviation tax. There also we heard arguments like, just two companies making aircrafts, Airbus and Boeing. There are others, but very insignificant. If you are talking about more efficient aircrafts, are you talking about discarding the old aircraft and buying new from our own companies? Now, discarding old aircraft and manufacturing a new one, on a life cycle basis, what is more efficient in terms of emission? Or shortening the life of existing aircraft, is it a good idea? If you also talk about emission that occurs in the process of manufacturing a new aircraft. So I think these are the three questions that you might address. Anybody?
Any takers for those questions? Yeah. On behalf of all of us. As a
Putting it back on me, unified front. So, thank you, Nitya, for your question, but I think it probably requires a couple more panel discussions. I don't think any one of us were saying that this EU CBAM implementation is actually a good thing, because I think that's essentially what you're trying to ask. So we are not making a value judgment that it is a good thing. What I did say that in principle, making producers pay or making any economic agent pay for the pollution that they are creating is something that we are not against. That principle is well accepted. And let me actually say something a little different, that while we keep recognizing that we are talking about carbon or greenhouse gases in particular and looking at the carbon equivalent of that, yes, it's a global stock pollutant, which is leading to temperatures rising and, of course, disastrous effects, existential problems that we are facing. But it also has a lot of local co-benefits, environmental co-benefits. So essentially, the fossil fuel-based energy that we are using rampantly, or we are unable to kind of really phase out as quickly as we would like to, has ramifications in terms of the health costs that we are paying. All of that is hidden cost. Just because it is not a cost that we directly face, and that is a problem that environmental economists have been shouting at the top of their voices and saying that just because you don't face it doesn't mean you don't incur it. So we are incurring it, but we are not accounting for it. So in that sense, in principle, yes, all of Global South and South Asia in particular would like greenhouse gases to be reduced, because they're the ones who are getting most adversely affected by climate change. The impact is the hardest on them. So yes, so in that sense it's a good thing, but the CBAM, the way it's been implemented, is not good, if that's what your question was.
No, I would like to add to that, an administrative challenge which comes out from the CBAM is that, it is the mostly EU importer may have the data, but the government of India may not have. Some of the national governments may not have the data which actually companies submit. It's actually directly needs to be submitted to the importer. And if it's a GVC, it goes through, the intermediate product is exported to a particular country, then the ultimate responsibility when the final goods flows to that EU market, again, the intermediary has to collect the geolocations and of all these plants, and have to submit it with the geolocation. So when we are looking at whether it will be a company-based, all these things have to be has to come out with more clarity. It may be an average, it could be for a country, or it could be for a product, it could be an average. So there are many things have to still come out. I think if somebody needs to second my answer, because I may be partial with my information, so you're free to come in. Yeah.
Okay, thanks. I think this observation that each company's production process is different, so each company's carbon price which they face in the EU market will also different. I think that is the whole basis of this complication, the how complicated the system is. But as our moderator has mentioned, it is not the responsibility of the exporter to prove that this CBAM is applicable on EU importer. So importer has to prove that the goods which he is buying from any country, so what is the carbon content of that goods? But ultimately it has to trickle down back the supply chain and he has to collect the data from the producer. So he has to prove, but on the EU side, they don't have to pay upfront. It's not the tax what the EU claims. What the importer has to do, they have to identify the carbon contents of the import, then they have to buy permits, where CBAM permits from the EU market and surrender those permits at the end of the year, equivalent to the carbon contents. So it's very complicated. So devil is in the details. So similarly, on the other issue of geolocation, it is, which will affect coffees and tea and other products related to wood. It is again the importer which has to show the transparency and other things that all these supply chains are free from human rights violation and they don't count to deforestation. Coming to the other side of which you mentioned, the CBAM, the potential of CBAM in the US, because EU has this domestic CBAM, they are providing these permits, so why they are doing through the CBAM, that they want to expand this to other markets. So they have kind of balancing argument that we have domestic price and we want to impose external price also to balance it. US doesn't have domestic price of carbon. Their argument is that they are accounting for the carbon through regulations. Their energy is more clean and they have strict regulation for the industry to cut emission. That's why they want to impose these carbon price on external markets. So their argument is completely different from that of the EU argument. Thank you.
Yeah, so I think we have come to a conclusion of a wonderful round of discussions. So they require a big applause, please, from the audience. Yeah, a small gift from the center side. I think Vishaka, can you do the needful?